The broadcast is now starting. All attendees are in listen-only mode.
Thank you for joining us for our webinar on the 11 legal issues that board directors must understand. Before we begin, just a few housekeeping items to share with everybody. First is that all attendees are in listen-only mode. However, questions can be asked at any time using the GoToWebinar client. There'll be a Q&A session at the end of the presentation where questions will be answered. If we're unable to get to your question in that time, don't hesitate to email us at info@virtualinc.com. The webinar is being recorded today, and the video and slides will be posted on the virtual website Knowledge Hub soon, and an email will be sent to you once they are live. At the conclusion of the webinar, please take a few moments to complete the survey that will appear in your pop-up window. And we're pleased to announce that Virtual is an approved CAE provider, and by attending this full webinar, you will receive 1 CAE credit. And with that, it's my pleasure to introduce to you Don Kaiser.
Good afternoon, and thank you for joining us today for our webinar, The 11 Legal Issues That Board Directors Must Understand. I'm Don Kaiser, Executive Vice President of Client Services for Virtual, and I'll be the moderator of today's webinar. Our featured speakers will be Jerry Pinero, of counsel with the law firm Howe & Hutton in its Washington, D.C. office. He has over 35 years of legal experience with a particular focus on tax-exempt organization. With Jerry on today's webinar will be Lisa Myers, Senior Director of Client Services at Virtual. Lisa has over 40 years experience working with associations and nonprofits, driving their strategy and governance processes. She currently serves as Executive Director for Virtual's client, the Academy of Eating Disorders. I'll now turn the webinar over to Jerry and Lisa.
Thank you, Don, and thank you for joining us this afternoon. What I would like to do is go through the slides fairly quickly so that we can leave as much time as possible for questions and discussion. I think the three most important points to take away from this presentation today are number one, the fact of the matter is, now obviously I'm speaking in generalities, but the fact of the matter is that nonprofit corporation statutes are written for the protection of officers and directors. As we'll see as we go through this. For example, the business judgment rule, as long as a director is acting prudently, he or she will be protected. Also, state nonprofit corporation laws have indemnification provisions, both permissive indemnification, which is very broad, and mandatory indemnification, situations in which the organization must indemnify the director whether it wishes to or not. And there are provisions regarding obtaining insurance, etc. So by and large, these statutes, frankly, are written to protect officers and directors as long as they're acting reasonably. So therefore, you should not be afraid to serve on a nonprofit board. And the third point that I want to make is that directors, and we'll see this later on, directors, if you're going to serve on a board, you have to exercise your independent judgment and your best decision making. So therefore, I think it's important that you do not want a bunch of yes people on the board who are simply going to vote in favor of everything or never disagree or dissent. And boards, as a general proposition, again, everything within reason, should actually welcome dissent. Maybe not even encourage it, but certainly welcome different opinions. You're not always going to have unanimity or uniformity, and that's not a bad thing. So those are the 3 points I would like to make in this presentation today as we go through some individual issues. All right, the basic standard.
Jerry,
yeah, go ahead, Lisa.
I'm sorry to interrupt, but I've been in addition to the state indemnification, I've been taught that it's best practice to include an indemnification clause in the association bylaws that provides some level of protection to individual board members from actions of the association. Is that still valid?
Yes, it is. But you know, the thing, you're looking at two interests there. You're looking at the interests of the association, quite honestly, and you're looking at the interests of the individual directors. From the association's point of view, to minimize risk to the association as a nonprofit entity, you want to be very careful about the extent to which you promise indemnification, because litigation can get awfully, awfully expensive. From the director's point of view, obviously, you want to have the maximum amount of indemnification you can possibly get. So quite honestly, there's a little bit of tension between the interests of the organization and the interests of the directors. But the basic point is still valid. A lot of bylaws provisions do include provisions that the organization will indemnify the directors, quote unquote, to the fullest extent permitted by law. So yes, that's still valid. And in terms of the basic standard for directors, as it says there, directors and officers have to discharge their duties in good faith with the care of an ordinarily prudent person in a like position would exercise under similar circumstances. So it's basically a comparative standard. Those terms are legal terms of art: good faith, ordinarily prudent person. Again, I don't want to overstate it, but it's a fairly generous standard. Basically, and this is very typical of nonprofit corporation law statutes. You could cite them from New York's a big association state, California is, Illinois is, Washington, D.C. is, et cetera. And they're pretty much similar. As long as you're basically doing a good, conscientious job, acting competently and reasonably, et cetera, you're going to be protected. Now, obviously, you can't guarantee that somebody is not going to be sued, but at the same time, you're going to have a defense, and the likelihood of any litigation is going to be minimized if you're acting according to this standard. And the statutes will provide that a director who meets these standards, acts in good faith, carefully, prudently, is going to be, if there is a suit, the director is going to be held not liable. This is another very important point, and again, this protects the board, or this protects the directors. The statutes, and this is from statutes, directors may rely on information or opinions of other officers, employees of the association, or outside consultants or advisors, like lawyers, CPAs, financial planners, board committees, etc. Now, there's some qualifications on that. If you have reason to believe that the person or the firm you're relying on is totally incompetent, then your reliance may not be justified. But again, in the ordinary course of business, you are entitled, as an officer or director, you're entitled to rely on the information, expertise, opinions of others. There's one example, there's a million of them. Let's say that the organization is, that somebody writes a letter to the board and says, I was the victim of sexual harassment, and unless you pay me $100,000, I am going to sue. Okay, so you engage employment law counsel, your general counsel, or you go out and hire somebody who specializes in employment law, and you say, evaluate this case for us. And the lawyer of the law firm comes back and says, in my opinion, this case has no merit whatsoever. Under no circumstances would I give this person $100,000. I'd give the person $10,000 in nuisance value, but that's it. So you act on that advice. You the director, you the board. Turns out the plaintiff sues, has a jury trial, and gets a verdict of $300,000. Now, somebody could say you directors were negligent because you could have settled the case for $100,000, you didn't, and now you ended up costing it $300,000. If anybody were to bring a suit over that, the board or the directors are going to win because they relied on the advice of outside, independent, experienced, competent counsel whose advice was don't settle the case. The fact that it went to litigation and the association lost or paid more than otherwise, frankly, is irrelevant. In terms of any liability on the board or an individual director.
Of course,
of
course they could still be sued. Of course, they could still be sued, though.
Well, yeah, but two things on that. The saying goes, anybody can be sued for anything. But in my own practice, so I want to be careful how I say this. In my own practice, and actually, Don, it's 42 years, more than 35. In representing nonprofits, I personally, or to the knowledge, the law firms I've worked at, I have never seen a director or a board of directors being sued. There's certainly threats to that effect, but usually and they may arise in the context of demanding financial information or membership lists or something of that sort. But in my own individual experience, all those cases have been resolved or settled through negotiations, and I never personally have been involved in any litigation involving a director and the director against the board against the director, or a member against the board or the director. So yeah, you can be sued, but I wouldn't. And this comes from somebody who worries a lot. I would not stay awake worrying about it. As I said before, and this is a matter of statute. This is statutory provisions. As long as you act in accord with the standard of care that is specified in the statute, you're not going to have any liability. And some of those bullet, we say, well, what does that mean, standard of care? Some of those bullet items, you have active oversight, you participate in board meetings, you prepare for board meetings, you take minutes. Two thoughts. Number one, this sometimes comes up. Well, actually, three things. Number one, I do not recommend recording minutes. For audio recording or a tape or something of that sort. You have somebody in there, a secretary or somebody who's taking notes, but I do not recommend literally recording meetings and then having to listen to them and delete the tapes or much less store the tapes. Just take notes. Secondly, I have seen a few associations who have open board meetings, meaning any member can come to the board meeting. Personally, I think that's a disaster. I would never recommend open board meetings. There may be ceremonial occasions or special occasions when you want to open up a board meeting or part of it. Maybe somebody's getting an award. Say, okay, we're going to open up the board meeting, for this presentation. But they have in your bylaws to say all meetings of the board of directors shall be open and public. I think is very ill-advised. And then the third point, as far as minutes are concerned, you probably heard this a million times. But basically, minutes are records of actions taken. And keep in mind that minutes are discoverable. So if you ever do have litigation, or you have a case of, let's say, somebody's bringing a discrimination charge, a sexual harassment or disability discrimination, and you have minutes which are virtually verbatim transcripts of conversations, and you have one director saying, for example, gee, I think we're at fault here, and I think we should pay the plaintiff $100,000. In fact, up to me, I'd pay him $200,000. You don't want that in your minutes because that's discoverable. So all that the minutes would reflect is upon motion duly made and seconded and approved by a majority vote, the board decided to decline the plaintiff's offer to settle her claim or his claim for $100,000. You don't want verbatim. The minutes are not a newspaper. All right. So anyway, I don't want to get to, there's probably enough on that. But in terms of meeting your standard of care, you hire competent staff and contractors. You have adequate insurance. Sometimes the question is, what's adequate insurance? It's going to vary case by case. Who knows? There are certain minimums. Like, for example, these days, general liability is usually a minimum of $1 or $2 million. And the way the insurance business works, I'm not an expert on this, but I understand once you get past a threshold, the more insurance you buy, the less it costs. So I'm making this up. But let's say for $1 million policy, the premium is going to be $50,000. Then the broker's going to say, well, if you want $2 million of coverage, the premium is going to be $60,000. So arguably, for another $10,000, you take the other $1 million in coverage. But that's one area where you have. That's a good illustration of relying on the advice and expertise of others. So you as a board say, well, how much insurance is enough? You bring in brokers, you bring in insurance carriers, you talk to other people, you look at surveys, etc., and you make a decision. And that is going to be in accord with this, satisfying this standard of due care. If you have a charitable foundation, that's important. The charitable organizations are maybe subject to higher scrutiny than C6 trade associations or social groups or something. But if you have a charitable organization, you want to monitor it carefully. Obviously, you want to be careful of your employment practices if you have any employees, if the association has any employees. If you're run by a management company, that management company is not your employee. That's an independent contractor, so you don't have to worry about it. And then obviously financial management, review your contracts and avoid defamation like disparaging products or people or attacking people's motives, etc. So those are some of the ways in which you meet the standard of due care. Okay. Now, this is another area that comes up from time to time. Business dealings between directors and associations, the conflict of interest. They kind of go together. Point here is that from a legal point of view, and I want to emphasize that because I know, as a lawyer, I know my perspective is narrow, but from a legal point of view, there's no law against directors having business relationships with their associations. There may be diplomatic reasons, there may be political reasons, there may be practical reasons why you don't want to do that, but there's no law that absolutely bans or prohibits directors from having dealings with their associations. As a matter of fact, if you wanted to, you could pay your directors. You could pay them a fee, and that does not violate any law. It doesn't violate the inurement provisions of the IRS that say the assets of an organization cannot inure to the private benefit of any individual. But if you do engage in business dealings between the directors and the association, and sometimes a director might give you the best deal. But in any event, as long as you meet certain criteria, as a general proposition, there's got to be full and fair disclosure, full, open, upfront disclosure. For example, if I'm a director and I say I think we ought to use such and such as our auditors to do our audits, and let's say the audit's going to cost $15,000, $20,000. If my wife is a partner in that audit firm, it's incumbent on me to disclose that. Now, I want to tell you, my wife's a partner, or my spouse is a partner in that audit firm. So that's number one. There has to be disclosure. Then number two, the transaction has to be fair to the organization. Take a sip of water here. So let's say my wife's firm says we'll do the job for $15,000. Maybe another bidder's going to do it for $18,000. Another bidder might do it for $13,000. As long as it's fair to the association, the transaction is fair to the association. And then number three, the interested director does not vote on the transaction. As long as you satisfy those three conditions, from a legal point of view, a director can do business with his or her own organization. As I say, there may be reasons, political, diplomatic, etc., why you don't want to do that. You don't want to give people the impression it's an insiders group, it's cronyism, or that sort of thing. But there's no law against having so-called interested director transactions. And that kind of relates to the conflict of interest policy. And again, people often think or assume that because a certain situation presents a conflict of interest, you can't go forward. And that is not true from a legal point of view. From the point of view of legalities, a conflict of interest situation is pretty similar to what I just was talking about with business dealings between the directors and the association. As long as there is full, open disclosure of all the relevant facts. Number two, the transaction is fair to the organization and the organization's best interest. And number three, the person who has the conflict does not vote on the decision to enter the transaction or not. You can waive, excuse me, you can waive a conflict of interest. Let me give you a concrete example of that, which I thought was kind of interesting. I had a situation, I guess it was last year, where a director on the board of a C3 in the educational field, a director importuned the executive director, who was an employee. This wasn't a management company. The executive director was an employee of the association with the staff. Okay, so the director importunes the executive director to hire her husband as an employee of the association. So you're going to have person A serving on the board of directors, person B, who's the executive director. As a director, she has influence over the executive director's contract, compensation, performance appraisal. She wants the executive director to hire her husband. Her husband's going to be a subordinate. So technically and theoretically, the executive director is going to have supervisory authority over her husband and give him his performance appraisals, give him his whether he gets a raise or not, disciplinary actions, et cetera, et cetera. That was kind of a messy situation. Now, from a strictly legal point of view, you could work all those things out. Ultimately, the organization decided not to go forward with it because it was just going to be too complicated and just, as somebody used the expression, optics. The optics didn't look very good, so they didn't go through with it. But to me, that was kind of an interesting example of a conflict of interest and what's entailed with that. So
Jerry,
that's the point on yeah.
That's a great example,
What?
but I do have a question.
Yeah.
Does the same principle apply to non-economic, say, policy decisions? I know that for many boards of directors, one of the sources of tension occurs when they're structured to include seats that represent specific constituencies. For example, the student members or all the members in California. And board members sit and always vote the interest of their special narrow section. I was taught that once you're seated as a board member, you should view all decisions through the lens of what's best for the association at large. So it raises all kinds of questions, like should a board member disclose other associations in the field that he's also serving as a director?
Well, Lisa, I think you have two questions. I think you have two questions there. The first question is yes. The conflict of interest that we're talking about, yes, it does apply to policy because you could have. I'm trying to think of something off the top of my head. Let's say our law firm we want to formulate a policy that we will not accept divorce cases. All right. And I may be opposed to that policy because that's one of my specialties, and I think if we take divorce cases, I can make a lot of money. So it's up to me to disclose within the firm. I'm not in favor of a policy whereby we don't take certain types of cases, but just to let you know, if we did take those cases, if our policy was to take those cases, I stand to personally benefit. Or again, I'd hire my spouse as a private investigator if we handle criminal law cases. So yes, it does apply to policy. The second question that you raised, I don't think it's an either-or situation. If you are elected to represent a particular constituency, then you have to represent that constituency. Now, sure, you have to take into account the broader interests of the organization as a whole, but you also have to keep in mind you were elected to represent a constituency. And one example that comes to my mind is this, from one association I used to work for about 20 years ago. Excuse me. The association had an annual exhibit, with exhibitors. You sell booth space, etc. The association wasn't doing too well financially or wanted to do better. So the proposal at the board was, let's double or triple what we charge exhibitors to exhibit at our convention. Instead of $10,000 a booth, let's charge them $30,000 a booth. All right. If I am the exhibitor representative to the board, I have a duty to my constituents. I'm representing the exhibitors to perhaps to oppose that. And that gets into what we're going to talk about before, the role of the dissenting director. I have a duty to represent my constituents. And I may say, well, if you do that, 50% of our exhibitors won't exhibit. That's too much, or it's too burdensome, et cetera, et cetera. But I also have to take into account the broader interest of the organization. The organization's in financial trouble, maybe without a dramatic increase in revenue from the annual trade show. The organization's going to be in trouble, et cetera, et cetera. So I don't think it's either or. I think it's both, and you have to balance. I don't know if I should say competing, but you have to balance the different points of view. Your duty to represent your constituents, in this case the exhibitors. Your duty as a director to represent the best interests of the association. And again, these all things tie together. Maybe you get an opinion of counsel. Maybe you get independent counsel, not the association, and you say, give me an opinion on what my obligation is here or what I should or could do. You can rely on that. Okay, so all these things tie in together. So that's how I would answer that.
That's really interesting. One more quick question. At APP, we ask all board members each year to sign an agreement about their responsibilities as board members, including a blanket statement that they agree to disclose any conflicts of interest. But does an association have responsibility for verifying potential conflicts that may not be disclosed?
No, the short no. You're entitled to rely on the good faith, honesty, and integrity of the person filling out the form. Now, again, if you have reason to believe that the person is not fully disclosing all of his or her interests, that may such knowledge or such reason to believe that there's something amiss here, that may create a duty to inquire further. But as a general proposition, people get elected to the board. You hand out a form that says, "Here's the conflict of interest form. Fill it out to your best of your ability. If you have any questions, let us know," etc. And the people fill those forms out. That's it. That's it. You don't have any further obligation.
Great.
Okay. So in terms of directors' right to participate in discussion, this is an area where I think if this situation was up, you need to check what your state law permits or may even require, because in my experience, boards are far too narrow and restrictive in what they allow interested directors to do. You certainly have a right to get information from the interested director. So go back to that example where I'm recommending my wife's CPA firm. You certainly have a right to get information from me. Well, Jerry, what's your wife's status in the firm? Is she a partner? Is she an associate? Is she going to personally profit if we give her the business? Could we get any discounts? Are you going to personally profit, et cetera, et cetera? You certainly have the right to get information. And it probably would not be illegal, and it might even be advisable at the board meeting to have me at the meeting, so I can answer questions that come up in the course of the discussion or the debate. Now, when you're ready to decide, excuse me, at that point, you may want to ask me to excuse myself from the meeting, or you may say to me, you can't vote on your own proposal. But I think organizations are far too restrictive in the information they get from interested directors unnecessarily. From a legal point of view, there's no reason to be that restrictive, and arguably it's actually a good idea to get as much information as you can. But that's something where you need to check state law. In terms of whistleblower policies, probably a good idea. Have a written policy. There are two provisions in Sarbanes-Oxley that apply specifically to nonprofits. They're on the slide. It's a crime for a nonprofit to retaliate against an employee. And here again, this is an example, I think, of how carefully the statute is written, basically to protect the organization. All right, look at what it says. It's a crime for a nonprofit to retaliate against an employee who provides a federal law enforcement officer. So if you go outside the board, or you go to a member, or you go to a state agency, etc., that provision doesn't apply. You're providing, it has to be to a federal law enforcement officer. It's got to be truthful information. So if you make something up, lie, mislead, etc., you're not protected. And then it's got to be about the nonprofits committing or planning to commit a crime, a federal offense. So just because you don't like the way the association spends its money, or you think it's foolish for the association to spend $500,000 on a cocktail party, that's not going to be enough to come under the protection of Sarbanes-Oxley. But there are those two provisions, and as I say, it's probably a good idea to have a whistleblower policy that basically mirrors what Sarbanes says, that if you no director, etc., is going to be retaliated against. Although the whistleblower policy probably is a little bit broader than the statutory provisions of Sarbanes-Oxley. Confidentiality agreements. This is an important point. A director, and again, talking generally, a director has a duty of confidentiality to keep confidential the proprietary information or the future plans of the organization, and that particularly applies to a situation in which the organization is threatened with potential litigation. And to give you a concrete example of that, I've had several examples of this. I've had a situation. You have a situation where the board or certain faction on the board wants to fire. I'm going to say fire the executive director, terminate the contract. And there may be one person on the board, or even two or three, who are big fans of the executive director and don't want his or her contract terminated. Okay, that's fine. If you're in the executive director's corner, you make the best argument you can. You fight as hard as you can so that the vote is not to terminate the executive's contract. But if in the course of a board debate or discussion, the board is saying, look, we think if we offered Tony, $250,000, he'll voluntarily leave. It's a breach of your duty. It's a violation of your duty as a director to go to Tony and say, hey, Tony, I'm not supposed to tell you this, but between you and me, the board's prepared to offer you $250,000, and I think they'll go to $300,000 or $400,000, so you ought to hold out. That's a clear breach of your duty of confidentiality. So there is that obligation. So I think that's enough on that. And then on the
Jerry, one
go ahead.
question. Going back to your reference to Sarbanes-Oxley, I've heard that while it was enacted in direct response and applies directly to corporations, it was enacted in direct response to public company financial scandals. I've heard that increasingly state not-for-profit governance and incorporation documents are incorporating provisions of the Sarbanes-Oxley. For example, I have seen it, or I've heard it said that the principles of having an annual financial audit and the creation of a finance committee and some other aspects of Sarbanes, is that something that an association ought to become familiar with because it may have implications?
Listen, I don't know for sure whether the association would need to be familiar with it or not. I mean, so many of these things are case by case. But you know, I think you raised a broader point, and I'm glad you did, which is this. Now, this is my own personal opinion, and this is the advice that I give to my clients. I don't know if other lawyers give the same advice to theirs, but it's this. Before you voluntarily undertake an obligation, make sure you know what the hell you're doing. And that applies not only to Sarbanes-Oxley, but it applies to any number of other things. You know, for example, let's say your organization has only 20 people. So you say, we're not subject to the Family Medical Leave Act. It only applies to employers of 50 or more employees. But we want to be progressive. We want to be one thing or another. So we're voluntarily going to agree to comply with all the provisions of the Family Medical Leave Act. If you know what you're setting yourself up for, fine, go ahead and do it. But if you don't know what you're doing, I would be very reluctant voluntarily to undertake obligations that you have no legal obligation to do. And actually, this goes back to the question you asked about indemnification. Putting a provision in the bylaws that says the association will indemnify to the fullest extent of the law all its officers, directors, and employees and volunteers. Before you adopt such a provision, my advice is you make damn sure you know what the heck that means and what that potentially, in a worst possible scenario, can entail. Because it might open the organization up to hundreds of thousands of dollars in potential liability. I'm not trying to scare anybody. If you know that, you understand that, and you want to accept that risk, fine and dandy. But to just put something in a bylaws provision or a policy provision that you don't really know the consequences of, I think is foolish, and I do not recommend it. So I'm probably not giving you a straight answer to your Sarbanes-Oxley question, but I think you raise a broader point. If something is voluntary, and my understanding is with these whistleblower policies, even with the IRS, they are recommendations of the IRS or the states. They're not legal mandates. Now, I don't know that for sure in every single state. If they are mandates, you have no choice but to comply. But if they're not, if they're simply guidelines or recommendations, like I said, think before you act. Now, if I may, on dissenting opinion, just the point I was making at the very outset, there may be situations in which you as a director not only have the right, but potentially the duty to dissent or to speak out. For example, I don't know, let's say your association is considering adopting a code of ethics. And the proposal is we want to put a provision in the code of ethics which says that no member will disparage another member or question the business practices or ethics of another member. And you know, excuse me, that's a potential antitrust problem, restraint of trade and competition, and you oppose that. In a case like that, you may have, not only the right to say, wait a minute, I don't think this is such a hot idea, but you may have a duty to speak out. So that's the only point I want. And and from my perspective, maybe it's easier said than done, but from my experience, again, obviously everything's within reason. I would not fear dissent. I mean, to some extent, I don't know if I go as far as say encourage it, but I would welcome it, or at least tolerate it. You're not always going to have unanimity or consistency. It was Ralph Waldo Emerson said, what does he say? Consistency is the hobgoblin of little minds.
How would a director safely express dissent? Make sure that there was a record of his or her expression of dissent. Would a certified letter?
Well, you could do that, but actually, Lisa, the primary vehicle would be the minutes. So I'm sitting in a meeting, and I would say to the secretary or the person taking the minutes, I want the minutes to reflect that I do not agree with this decision, that I dissent from this decision, and have no part of it. I mean, that would be the primary vehicle. A letter would be another means. Maybe an article in the association's publication, journal or newsletter. Dear members, that'll be published in a newsletter. I write to express my disagreement with our organization's decision to adopt an ethics policy. Or maybe it's not to pick on ethics. Maybe it's not even a particular provision. Maybe what you're thinking, your position is, look, I don't think our association should get in the business of enforcing an ethical policy at all. It's not our business or our purpose as a trade association or a nonprofit or a charity to govern people's ethics. We assume that. So I'm opposed to any ethics policy. Never mind a particular provision. So those are some of the ways of doing it. There are probably others too. On the discipline of directors, the point I'm going to make here is this. Again, as a general proposition, the fact of the matter is it is very, very difficult, quote, to discipline a director, a member of a board, because if those people are elected, some state statutes will provide that a director can be removed only by the class or category of voters that elected him or her. So if the members elected a director, the other directors can't simply remove that person. And the director, him or herself, may threaten legal action. They say, if you remove me from the board, I don't think you have the legal right to. I'm going to sue you and get a threatening letter from an attorney. So the truth of the matter is, it's very difficult to discipline a director. But if you do that, if you go that route, as I say here, you have to make sure you're complying with state nonprofit law, and you have to provide fundamental basic due process, right to the charge, opportunity to respond, and at least one level of appeal. On international associations that engage in international activities, yes, all nations take the position that their laws have extraterritorial jurisdiction. So, for example, I just got back from a meeting of a trade association in Montreal, Canada. And I told the members there, I said, even though we're in Canada, keep in mind that we still conduct our meetings in accord with U.S. federal antitrust law. Because any action in a foreign country that has consequences in the U.S. Is actionable. So the short answer is, if you have foreigners, yes, they have to comply with U.S. law. And if you are operating in other countries, you have to comply with those laws. And I think this new general directive on privacy is a good example. Associations are spending a lot of money and time complying with the GDPR because they have members in the European Union. And one question came up: can people be prosecuted in the U.S.? Absolutely. There was a case in 2012 in which the Department of Justice sued two Japanese companies, automotive electronics or something, fined them $500 million for price fixing, and 4 executives of those companies went to jail, 2-year prison terms in the United States. And the same thing applies. You go over, if you're having legal problems in India or China or someplace, and you set foot in those countries, you might get, if you could get arrested. So again, I'm not trying to scare anybody, but the short answer is yes, the laws do apply extraterritorially. Final point, I think, Not the final point. Just a note on officers. An officer's status may be somewhat different from a director's. I mean, generally, everything I said about directors does apply to officers as well. One example is the executive director. Oftentimes, that person is a paid professional, is a director, but a non-voting member or ex officio or something of that sort. And any action, it's probably easier to get rid of officers, oftentimes because the board appoints them. But any action cannot be contrary to the officer's contract rights. Finally, a word on policy. We were talking before about policies. It's this, have all the policies you want, but you have to make sure of three things. If you don't enforce, number one, know what you're doing. That's what I said before. You want to adopt a policy on this, that, or the other thing. Make sure you know what you're doing. But then number two, if you're not prepared to enforce that policy, don't bother having it in the first place, because it's worse to have a policy that's ignored or inconsistently or sporadically applied than to have no policy at all. Okay, so I'll stop there.
I have a question about that. I understand what you're saying, Jerry, and concur completely with it, but I do have a question. Under what circumstances can an exception be made to a policy? For example, just this little silly example, but we have a policy that abstract submissions for our conference must be in by midnight on X date. It's part of our policy manual. The board has adopted that. But let's say that we have a very special circumstance. Can we deviate based on special circumstances from a policy, and what does it take to do it safely?
Oh, sure. As long as you can, well, let me say two things. To answer the first question, what to do it safely, basically what you want to have principles of application. The best things to have is to have guidelines. Maybe you have a grace period. Let me say, the deadline's midnight, but if we get something within 60 minutes or 10 minutes or something, we'll still accept it. But you also have to look at the situation itself. It's one thing to say abstracts of presentations have to be in by midnight or they won't be considered. But now, suppose you put out a very formal, detailed RFP to undertake a very expensive project, lease new space or renovate your offices or put a new computer system in that's going to cost $1 million or something, and you say all proposals must be postmarked by such and such a day and time. In that type of situation, you have to look at it case by case, but I'd be very slow to waive or make any exceptions to that policy. Maybe that's not exactly a policy, but you have to look. You have to look at what the policy applies to.
Great.
I think. Sure. Okay. Anything else? Don, are you there?
Yes. Well, thank you all for joining us today. We appreciate the time. Thank you, Jerry. Thank you, Lisa. It was a wonderful presentation. For all of you joining us, we will email you the webinar recording and the slides soon. We'd like you to stay on and take our brief survey. And again, I just want to give a special thanks to Jerry Panera of Howland Hutton. Appreciate you all joining us today, and we'll do another one soon.